What happens to a deceased person's bank accounts? That's a very good question, and the answers vary based on several things. And let's talk about what those things are. What are some things to ask the bank, to ask around your family, to maybe read from the documents you may have. You may have some past statements, or maybe you receive some correspondence from the bank about those bank accounts. So one of the things that we need to know is there a joint owner, a co-owner to that bank account? Because if we have a joint account with someone else, be that a spouse or a child or a friend, when one owner dies, usually the other owner gets everything. So they have full access to it. Now it's their bank account. The same thing with real property. If it's owned as joint tenants with the right of survivorship, it goes to the survivor joint tenant, kind of with the same thing with the bank accounts. If there's a joint owner, they usually receive that. Now, here I want to talk about the difference between being a joint owner and being a signer on the account, because there is a big difference and it matters. Joint owner means just what we talked about. You co-own that bank account. Signer means you just have the authority to access that bank account, write checks and things like that, but you don't own it. And the signer powers terminate upon the death of the person. So if you are able to write checks on mom's account and access it and ask for statements, but you don't co-own it, then the signer powers terminate upon mom's death. And then it goes to the next two things that we're going to talk about. Basically, is there a payable on death designation or not? So mom passed. One of the questions for the bank is there a joint owner? I think I'm on the account. What does that mean? Just make sure you fully understand that. Do I co-own it, or am I just a signer? And then, is there a payable on death designation? Is there a beneficiary listed? If there is a beneficiary listed, you should be able to go with the death certificate, sign a form at the bank, if you are the listed beneficiary, of course, and collect that money. They're just going to give you a check. If there is no beneficiary listed, you go to the bank, there is no joint owner, the signer powers, even if you had them, they're now done. There is no payable on death. So what do? You have two options. One, some states allow you to collect a bank account. This is Oklahoma, under 50,000 at this time anyway, with the smallest state affidavit. Some banks, maybe in other states, may be different. They will ask you to file for probate. What does that mean? It means you likely have to hire an attorney, go through the court process, get appointed as personal representative. Then as personal representative, you have the authority to access that bank account, use that money for the estate. At the end of the probate, if there is anything left, it gets distributed to the beneficiaries. Who are the beneficiaries? It depends. Is there a will? And we know who the beneficiaries are. Or if there is no will, in Oklahoma, the law dictates who gets what. So it goes based on that. Again, ideally, you have an attorney to help you through the process. I hope this video helped. I know it's a very confusing time and overwhelming. The best thing, again, would be to get an attorney. Some of them offer free consultations. We do free phone call consultations. But even if you spend an hour and pay an attorney, a local attorney, for an hour of their time to kind of figure out what to do, what to ask. Sometimes banks may or may not know, or may not want to help a whole lot. So having someone on your side will make a big difference. Please email me if you have suggestions for future topics, or if there's something that you would like me to talk about more. And thank you so much for watching. Be sure to subscribe to our channel so you can get notifications when future videos are posting.